Good morning and welcome colleagues, invited guests, members of the general public who are following today's proceedings of the Standing Senate Committee on Legal and Constitutional Affairs. Today we begin our pre-study on Bill C-23, an act to amend the Canada Elections Act and other acts. This bill proposes amendments to numerous aspects of Canada's electoral law, along with related amendments to the Telecommunications Act, the Electoral Boundaries Readjustment Act, and the Director of Public Prosecutions Act, among other acts. The bill is currently being studied by the House of Commons Standing Committee on Procedure and House Affairs, which has heard from a number of witnesses on certain elements of the bill. Our task as a committee is to conduct public hearings on the subject matter of the bill, which will allow us to report on some of our findings prior to its introduction in the Senate. And to begin our deliberations, I'm pleased to welcome to the committee the Honorable Pierre Poilievre, Minister of State for Democratic Reform, and the Minister is accompanied by officials from the Privy Council, Isabelle Mondou, Assistant Secretary to the Cabinet, Legal Operations, and Marc Chenier, Senior Privy Council Officer, Council Democratic Reform. Minister, welcome, and we'll begin with your opening statement.
Merci beaucoup, Monsieur le Président. J'aimerais tout d'abord.
Thank you, Mr. Chairman. First of all, I'd like to thank the committee for the invitation to appear today before a very distinguished group with a great deal of knowledge. I expect to learn a great deal. I have with me Isabelle Mondou and Marc Chenier from the Privy Council, who are experts in technical matters, and I am sure that they will be giving you some explanations today to fill up certain gaps in my own knowledge.
Marks. The Fair Elections Act is reasonable and it is common sense. It will ensure everyday citizens are in charge of democracy by putting special interests on the sidelines and rule breakers out of business. The bill makes it harder to break the law, and it makes it easier to vote lawfully. It closes loopholes to big money, imposes new penalties on political imposters who make rogue calls, and empowers law enforcement with sharper teeth, a longer reach, and a freer hand. It protects voters from rogue calls and impersonations with a mandatory public registry for mass calling, prison time for impersonating elections officials, and increased penalties for deceiving people out of their votes. As I said, it gives sharper teeth to the Commissioner, which means tougher penalties for existing offences in the Act. Longer reach means empowering the Commissioner with more than a dozen new offences to combat big money, rogue calls, and fraudulent voting. Finally, a freer hand means the Commissioner will have full independence, with control of his or her staff and investigations, and a fixed term of 7 years so that he or she cannot be fired without cause. The bill will require people you provide ID when they vote. That does not necessarily mean they should provide photo ID or even government-issued ID. Neither are necessarily a requirement for people voting in Canadian elections. In fact, Elections Canada provides, through its legal discretion, 39 different forms of authorized ID, everything from utility bills to Indian status cards to student cards to letters of attestation from soup kitchens, student residents, homeless shelters, and Aboriginal native bands. These are a full list that will provide people with all of the ID they need to cast their ballot. It will also make rules clear, predictable, and easy to follow. Parties will have the right to seek advance rulings and interpretations from Elections Canada and receive them within 45 days of a request, similar to the service provided by the Canada Revenue Agency. Elections Canada will also be required to keep a registry of interpretations and provide for consultation with and notice to parties before changing them. Big money from special interests can drown out the voices of everyday citizens. That is why our laws strive to keep it out. The Fair Elections Act will ban the use of loans to evade donation limits. However, the bill will allow parties to better fund democratic outreach with small increases in donation limits, while imposing tougher audits and penalties to enforce those same limits. The Fair Elections Act will make modest adjustments in the spending limit and the donation limit of the donation limit will rise to $1,500 and the spending limit will rise by 5%. The total ban on union and corporate donations will remain. It will provide better customer service by focusing Elections Canada's advertising on the basics of voting, where, when, and what ID to bring. Also, the Fair Elections Act will require Elections Canada to inform disabled voters of the extra help available to help them cast their ballots. Things like wheelchair ramps and braille services for disabled voters are available but often not known to the people who need them. The Act will require Elections Canada inform those people of these services. The Act will also provide an extra advanced voting day, which will make voting more accessible. There are two things that drive people to vote: motivation and information. Motivation is what political parties and candidates provide. Information is what the agency is meant to provide. That information is the where, when, and how to vote, the special voting opportunities like voting by mail, voting at the Elections Canada office, or voting in an advance ballot, many options of which Canadians are not typically aware, but should be. And it is on this latter priority of providing information that Elections Canada's advertising budget will henceforth focus with the adoption of the Fair Elections Act. Now, the reality is that there's been a lot of debate on this bill. The CEO of Elections Canada has indicated his opposition to it, and let me just say that I am at peace with that. The reality is, regardless of amendments and improvements that the bill would potentially have included, the CEO will not ultimately support it. His recommendations really boil down to three broad requirements for him. He wants more power, a bigger budget, and less accountability. The amendments that will be under consideration in the final bill that will be adopted does not move in that direction. It's not that I'm unaware of his recommendations. I am very much aware of them. It's just that I disagree. And we live in a democracy whereby parliamentarians decide on legislation and officers of Parliament advise. The CEO of Elections Canada serves Parliament, not the other way around. That is democracy. When a head of a government body asks for more power, the burden of proof falls to him to demonstrate the need. Let us consider some of examples of the new powers the CEO seeks for himself. First, he believes, and I quote from his recommendation, that upon the request from the CEO, political parties be required to produce all documents necessary to ensure compliance with the Canada Elections Act. Let's examine this. It is difficult to imagine what power the CEO seeks here that he does not already have. Does he need the power to fulfill his role of providing parties with a post-election reimbursement? Well, the truth is, colleagues, he already has that power. Under Sections 430 to 435, the existing Canada Elections Act provides that parties must present a detailed, quote, election expense reporting. Section 430(1) reads as follows: as soon as practicable, after a general election, the auditor of a registered party shall report to its chief agent on its return on the general election expenses and shall make any examination in accordance with generally accepted auditing standards that will enable the auditor to give an opinion in the report as to whether the return presents fairly the information contained in the financial records on which the return is based. In other words, the auditor is required by these sections to report if the party's return is incomplete, does not fairly represent the financial records, or is missing proper financial documentation. Under Section 435A of the existing Canada Elections Act, the CEO is only required to reimburse parties if he is satisfied that the party has met all of the reporting requirements. In other words, if he wants more information, he can simply ask for it. If he does not get that information, he can refuse to authorize the party's reimbursement. The CEO can simply refuse that money rather than having to possess a new power to requisition documents. Which raises the question, the fair one: what if Elections Canada has already paid the party its reimbursement when he identifies a problem with the party's election filing? The answer is that filing false information with Elections Canada in one's return is an offence under sections 427 and 431 of the existing Act. And the CEO can inform the Commissioner, who's the investigator, of such an allegation. He can investigate it, and the Commissioner, through a judge, can demand access to any documents and information he needs. This power properly rests with the Commissioner, who already has it, and not with the CEO. Mr. Chair, the next demand from the CEO is that he have the power, that his agency have the power to compel documents which could potentially cause, I believe, serious breaches to the privacy of Canadians. For example, voters often tell political parties who they're going to vote for. They're confiding their secret ballot intentions in that political party. They are not authorizing that their secret ballot vote be transmitted onto a government agency. Therefore, it would be a breach of the voter's privacy if a government agency was able to have unrestricted access to the party database that contains information that the voter has only decided to confide in that party and not in a government agency. If Mrs. Jones, for example, tells Party X who she's voting for, she wants Party X to have that information. She has not authorized that information to fall into the possession of a government agency, and therefore she should not have to have her secret ballot voting intentions passed along to that agency. Next, Elections Canada has suggested that it should have the power to compel testimony before even laying charges. The police do not even have these powers when investigating murders or armed robberies. They are able to secure convictions even with complex evidence and uncooperative witnesses without compelling testimony. If Elections Canada cannot do the same, perhaps that says something about the cases being investigated rather than the powers of the investigator. Now I'd like to move on to the issue of the independence of the Commissioner. The Fair Elections Act makes the Commissioner of Canada Elections independent from the CEO of Elections Canada. The investigative function will be housed in the prosecutor's office, but will have explicit legal and practical autonomy over his investigations. The current Commissioner, Yves Cote, is invited to stay on in this role, as will his staff, and he will have a fixed 7-year term which he will complete should he so wish. He will bring with him his staff, and all of his investigations will be grandfathered. All active investigations will continue uninterrupted by this change. Now, it is no surprise the CEO would like to remain in charge of the Commissioner. He is fighting to retain this power, making some incredible claims and inventing some novel legal principles to do it. Let us examine Elections Canada's arguments on this point. First, the agency says that the Commissioner's investigations are already independent. This is demonstrably untrue in law and in practice. You only have to start by going to Elections Canada's website to find that the agency itself, Elections Canada, handles all the media relations for the investigations done by the Commissioner. And I can show you, just need to go to elections.ca and you will see that the contact for all investigations on all the press releases is Elections Canada Media Relations. A 1877 number is attached. The CEO regularly speaks on behalf of the Commissioner's investigations. Further, the CEO hires the Commissioner under Section 509 and can fire him at any time as he serves at pleasure. He has legal authority over the Commissioner's budget and his staff. That is not independence in practice, nor is there independence in law. I turn your attention to Section 510 of the existing Canada Elections Act, heading, and I quote, Chief Electoral Officer to direct inquiry. It goes on in the same section. The Chief Electoral Officer shall direct the Commissioner to make any inquiry that appears to be called for in the circumstances, and the Commissioner shall proceed with the inquiry. That is correct. The Chief Electoral Officer shall direct the inquiry, is how the Act is currently written.